Thind versus U.S. immigration case. I'm sure all of you are eager to hear her tonight. She'll be joined by others after her talk for a panel discussion. Jasmine Singh is an attorney, cycling instructor, dancer, and social justice advocate. After graduating with her BA in political science and English from the University of Michigan in December 2004, she attended UCLA School of Law and graduated Order of the Coif in 2008. While in law school, Jasmine specialized in critical race studies and later published the article, "Everything I Am Not Made Me, Everything I Am, the Racialization of Sikhs in the United States," is in the Asian Pacific American Law Journal. Jasmine practiced law at several prominent firms in San Francisco from 2008 through 2015, focusing on complex commercial litigation while maintaining a strong pro bono practice. She has organized and volunteered in mentorship programs for underrepresented communities and maintains a strong tie to the flourishing Sikh academic space through her participation in Sikh wars. Jasmine joined 24-Hour Fitness as corporate counsel in early 2016 and enjoys negotiating and drafting commercial agreements in her gym clothes. Please join me with a warm welcome to Jasmine Singh.
Thank you for such a wonderful introduction. Good evening, everyone.
Good evening.
I want to start by thanking all of you for being here and supporting Sikh Lens. This film festival fills a huge void in all of our communities and gives voice to a lot of people that would not have one otherwise. Also, a major thank you to Chapman University for hosting this event and being so involved in Sikh Lens. I'm so impressed by the institution's commitment to intellectual curiosity as well as diversity and inclusion. So thank you to all of you involved from the Chapman side. I'm here to tell you a little bit about Bhagat Singh Thind's quest for U.S. citizenship. Not his life per se, but instead his brief submitted to the court and the court's ultimate findings. I'll start by framing the discussion around race, racism, immigration, and then get into Mr. Thind's actual case so that we have a little bit more context for our discussion. Bhagat Singh Thind applied for citizenship the first time in July of 1918 in the state of Washington. The statute governing his application required that he be a quote-unquote free white male in order to obtain his citizenship. The court sided with him and granted him citizenship, but it was revoked just a few days later when the court decided that he actually didn't qualify as white under the statute. Then Thind applied for citizenship in Oregon in May of 1919. The district court granted Thind's request, finding that he was in fact white under the statute. But the finding was again appealed by the Naturalization Office. And Thind's case was ultimately appealed to the Federal District Court of Oregon. And Judge Wolverton in that court found that Thind, like the many judges before him found, was white under the statute, and therefore he was deserving of naturalization and citizenship. Again, this was appealed. Ultimately, the matter was raised and appealed to the Supreme Court of the United States, where Mr. Thind was denied citizenship, again under the grounds that he was not white. That finding, the court's holding, was not in any history book I read growing up as a kid in Arizona, nor was the statute that governed his application that required him to be white. I did not learn of Mr. Thind's quest for naturalization until I was in college and took an Asian American Studies course and sought out that knowledge affirmatively. He was not a part of the history that I learned, the history that was presented to me as complete, balanced, and unbiased. And so as I began to ask questions about Mr. Thind, I learned that my own great-uncle, my mom's Tayaji, came to the United States in the early 1920s. He moved westward with the Okies, a group who I until then understood to be completely white, and settled in Arizona and attempted to become a farmer there. There were, however, alien land laws that prevented his purchasing of land in Arizona. Again, I did not learn of those land laws while I was a history student in Arizona. Later, I learned that it was anti-miscegenation laws, which prevented interracial marriages, that prevented my Thayaji from being able to marry his ultimately white wife. Again, I did not learn of any of those laws while I was a student in high school in Arizona. All of those things were omitted from the stories that I were told were history. And so this term history, it connotes to us some kind of neutrality, a sense of an unbiased, unmotivated accounting of events in an effort to memorialize and disseminate information for future consumption. Many of us know, however, that history, notwithstanding this air of neutrality, is anything but. History is a loaded, biased account of events past, repackaged, propagandized, and perpetuated in order to shape and pass forth a particular narrative or build and maintain a specific structure. The term history, like meritocracy or law, history's comrades in oppression, is used to legitimize untruths, wash and whitewash observation, absolve individual actors of bad faith, and create and instantiate a system of oppression so powerful it brings demagogues to office, and so invisible that we cannot even see the dirt on the hands of those propping it up. The theory work of critical race studies asks us to consider individual narratives or personal histories as challenges to the institutional historical narrative, as places to locate truths that depart from what we are told about ourselves and about others, as moments to learn that what we think we know is universally true is anything but. What then do we make of historical personal narratives that are inexorably intertwined with these formalized means of knowing the world? In other words, what can we glean from things like briefs submitted to the courts, depositions, appeals, pleas before the law? How do the personal narratives contained therein become a part of or excluded from history as we learn it and history as we know it? And importantly, how does the law and the forms through which the law is historicized take advantage of these narratives to retell us stories about who and what we are? This is the ultimate lesson of Bhagat Singh Thind's application for U.S. citizenship in the early 1900s and the Supreme Court's ultimate determination of his case in 1923. By reading Thind's brief to the court and the court's opinion, which is essentially an interpretation of Mr. Thind's personal narrative, we are reminded that it was individual actors, judges, career servicemen that were charged with determining the merit of one person's story. That these individuals were tasked with applying laws that hope to be just, but which are really just the product of individual and collective experience. That the court, while aiming to be fair, is not inherently possessive of that quality, and that litigants' arguments are informed by their social and political reality, a reality shaped and informed by white supremacy and an institution bent on preserving that structure. So some of you, aghast at my use of the term white supremacy, are ready to dismiss the existence of the structure outright, flabbergasted that a discussion of justice could start with what you may deem as an accusation. But at the very center of the discussion around immigration, naturalization, citizenship, nationalism, patriotism, and what those things confer to you, ultimately, personhood, is whiteness. Who is white and who is not? Who determines who is white and who does not? What does that determination confer and what does it not? And importantly, what are the lasting impacts of those determinations? And so even when the instinct might be to resist this truth, the case of Mr. Thind, like the cases of undocumented Mexican immigrants or the impending registration of Muslims in this country, or the struggle of the Black Lives Matter movement, is a story of whiteness and power. And the lesson I hope we can glean from Mr. Thind's quest is that we must open our eyes to that reality and make the decision to either be complicit or object. And so before getting into Mr. Thind's story, we'll start at the start, which is the naturalization and immigration laws of the late 1800s and early 1900s. So before the Civil War and for a short time thereafter, there was little formal immigration law governing who could and could not become a citizen. Between 1790 and 1802, Congress established naturalization requirements that included residency in the country for 5 years, good quote-unquote moral character, and that applicants be free white persons. This law then essentially transformed Western European immigrants into United States citizens. In 1870, the law was amended via revised statute section 2169, which proposed that naturalization was available to 3 categories of people. First, free white persons. Second, aliens of African nativity. And third, persons of African descent. Because the courts were interpreting these laws, it was up to the judges to determine who was or was not a white person, who was or was not a person of African nativity or descent under the statute. But there was little direction as to who qualified under any of these categories, and judges in different jurisdictions had different understandings of whiteness, relying on their common understanding of race and deciding cases on an individual basis. In 1906, the Bureau of Immigration and Naturalization was formed, which had the purported mission of providing for a uniform rule of naturalization. The Bureau and its administrators began executing the work of determining who should and who should not be afforded naturalization and citizenship. The law continued to cause confusion and led to different results in different jurisdictions. Facially, the law mixed color, whiteness, with natural origin, Africa. By combining what some presumed to be a racial category with national origin, administrators then began conflating the two, which confused the issue further. Several lower courts issued conflicting opinions on who was white, Syrians, Jews, Arabs, and who was not, Black, Mexican, Indian. So thus began the formalized process of the construction of race. Who qualifies as a certain race, what attributes provide for that qualification, and what that qualification meant or conferred. And so we'll get into a quick primer now on what race and racism and racialization are before we get into the tenth matter. So what is race? So quick show of hands, how many of you here believe that race is a biological inevitability? Raise hands if you believe that, which is fine. So maybe some, but you're a little shy to say it. So biology, of course, is a part of the construction of race, right? Your phenotype is determined by your biology, but your phenotype is not all that contributes to the race that people perceive you to be, or the quote-unquote race that you are. So while biology plays a role in one's phenotype, race is actually a social construct. It's not a biologically inevitable trait, but is instead constructed by the bounds of what we think we know to be true and an attempt to organize or classify those things. So there are not genetic characteristics possessed by all African Americans and not all non-African Americans. There are no common genes to all whites. Race is not marked by some genetic frequency. In fact, greater genetic variation exists within populations typically labeled black and white than between those populations. Ian Haney Lopez is an academic scholar who publishes on race, and he contends that race is neither an essence nor an illusion, but an ongoing, contradictory, self-reinforcing process subject to the macro forces of social and political struggle and micro effects of daily decisions. And so we get to the process of racialization. Racialization is the process through which individuals are mapped into certain groups based on specific traits or characteristics, and then treated in a specific manner based on the meanings that are attached to those specific groups. So we can better understand racialization by using schemas or cognitive structures that represent knowledge about a concept or a type of stimulus, including its attributes and the relations among those attributes. So I know that's a mouthful. I drew this funny little thing with smiley faces so that I can hopefully help everyone understand. So society provides us, the perceivers, with a set of racial categories into which we map an individual, which is the target. After the person is assigned a racial category, implicit and explicit meanings associated with that category are triggered. These racial meanings, in turn, influence our interpersonal interaction with that target, which in turn influences what resources and benefits those targets receive. So there are three components in the racial scheme: the tools, the categories, and the meanings. All three are contingent, constructed, and contestable. None is biologically inevitable, further illustrating the social component of this construction of race. So by way of example, let's think about if you see someone who's a male who has white skin, wearing a turban, but speaking in Spanish. Any one of these markers alone might influence you to filter that person into a specific category, right? Using those tools. So the tools are, his skin color is white. So that tool might make you put that person into the white category. He's wearing a turban though. So you think, okay, that one trumps. So actually that tool is going to make me put him into the Sikh racial category. Oh, but he's speaking Spanish. Does that change where I put that person, where I filter him? Let's say instead of in the US or in this room, you saw that person in Oaxaca, Mexico, and they're speaking Spanish. Are you more inclined then to filter that individual into the Latino or even the Mexican racial category because now you've placed them as a part of their national origin? So this is an example of different tools being used in different moments and in different places and different contexts to place people into various categories, which in turn influences the rest of the map that you see here above. So we use the different tools like phenotype, language, nationality, descent, and religion to filter folks into different categories. But those tools, they change over time. Sometimes religion filters one into the white category. For example, Middle Easterners or Latinos, historically by the courts, were actually qualified as white because they were Christian. The categories themselves are also in flux. There's no existing set of categories that is maintained over time. A religion, for example, can become a racial category. Take, for example, post 9/11, especially the construction of the quote-unquote Muslim racial category, which Sikhs have also been filtered into, and more generalized as the terrorist category. So it's important to acknowledge that a target can respond to the map by arguing first that the tools that the perceiver is using to map that person are defective. Second, that the categories that they're being placed into are incorrect. Or third, that the meanings that are attached to those categories actually have no basis in reality. So we've seen examples of all of these responses over time in our own community. For example, post 9/11, Sikhs tried to explain that their appearance, their phenotype, actually was filtering them into the wrong racial category. They said, we are not Muslim, look at us. We are Sikh, don't put us into their racial category, put us into our own. So now we finally get to where we're going, which is the Thind case. So Thind, too, responded to his mapping into the non-white racial category through his brief to the Supreme Court, in which he sought affirmation of the lower court's finding of his whiteness. After the district court found that Mr. Thind qualified as white, the matter was appealed to the Ninth Circuit and ultimately reviewed by the Supreme Court. Before getting into the actual details of Mr. Thind's appeal, it's important to know what precedents was in place in 1922 when his case was being brought up. The Ozawa v. United States case was the first Supreme Court case to construe the meaning of white persons under the statute in 1922. This is a picture of Mr. Ozawa. He's a Japanese man that applied for citizenship, arguing that he was Caucasian as the term was popularly understood. He looked white, he only spoke English, he only associated with white people, and he was Christian. Ozawa used these tools in order to map himself into the white category. But the court ultimately held that regardless of his skin color, language, affiliations, or how people understood him, he did not qualify as white because he was not Caucasian as the term was scientifically understood. So the court was proposing a different tool, science. What does science say you are? Thind, having this in mind, appealed his case to the Supreme Court and submitted his briefs. Mr. Thind obviously had a very different phenotype than Mr. Ozawa, but nonetheless made similar arguments. Thind argued in the Ninth Circuit and the Supreme Court that he was white because he was Caucasian as the court understood the word in Ozawa. After stating just once that Thind was a Sikh born in the Punjab region of India, Thind actually adopted the identity in his briefs of a Hindu, arguing throughout his briefs that because he was a Hindu, he was entitled to the classification in the white category. He began by arguing that skin color alone was not the proper tool for placing him into a racial category. He noted that people of various colors, quote unquote, had been accepted as white, including Jews, Syrians, and Armenians. He further submitted that one's quote unquote home does not control race, saying race is a matter of blood and descent, not matter of residence, thereby appealing to the court's prior ruling about science, blood, and descent. Following that logic, Thind argued that the court should look to several tools as proof that he is Caucasian. First, he argued that he descended from Aryans that had entered certain parts of India. Second, his language was an Aryan one, and there was no other imposed on his people. Here, Thind began to actually draw parallels between his language and his position in India, and one that judges in the United States may have been more familiar with, that of Africans or people of African descent. Thind said, many scientists have attempted to show that similarity of language does not prove similarity of race. Of course, this is true in some cases, as for instance the American Negro, although speaking the English language could not be classified as Caucasian. But we know that the American Negro belonged to a subject race and acquired the English language from those who subjected him, while in the case of the Hindu history, it shows that he has never been subjected by any race of conquerors who materially changed his language. So I make two side points here. First, African descendants and African aliens from Africa were actually permitted citizenship under the statute, and Thind was actively resisting being placed into those categories. Think about why. The second thing that I would employ you to think about is, think about the effects of colonialism in India and whether you agree with the fact that Hindus were never subject to a race of conquerors. Next, Thind argues that Hindus of the Aryan race and Englishmen have similar physical structures and that a light-skinned Hindu could pass for an Englishman. He also argued that he was a war veteran and that a man who fights for the flag should be entitled to come under the flag. His love for America, his attorney wrote, is evidenced by his conduct. To reverse his case would result in the disenfranchisement of a number of Hindus in all parts of the Pacific coast and other parts of the US. Again, I implore you to think about the arguments that are being made there and the arguments that continue to be made now, even 100 years later. Thind argued his religion, Hinduism, mandated strict adherence to the caste system. There is no melting pot in India, he said. The high-class Hindu regards the Aboriginal Indian Mongoloid in the same manner as the American regards the Negro, speaking from a matrimonial standpoint. It would be just as disgraceful for a high-class Hindu to marry one of the lower castes as it would be for an American gentleman to marry a member of the Negro race. He explained that the caste system was an effective barrier to prevent a mixture of the Aryan with the darker races in India. This appealed to the one-drop rule of purity and race that was so predominant in the United States. Thind's proposed mapping tools were influenced by his awareness of the perceiver's conduct and their desire to define and maintain what whiteness meant. Thind, a Sikh man, did not resist his placement in the Hindu racial category. Instead, he embraced it for strategic reasons. He tried to place that entire category, at least upper echelons of it, within the white category. Given what we know about Sikh history, this placement might seem a little problematic to us looking back, because historically Sikhs were co-opted by and forced to convert to Islam at some times and Hinduism at others, and there was an active attempt by the Sikh community to distinguish itself and assert an independent identity. That said, there was an understanding in the US, and a term used in the US, that for all South Asian immigrants, they would be referred to as Hindus. So it's possible that Thind could have just been taking advantage of a term that was already being applied to him and others similarly situated. What's important to note is that Thind actively resisted placement in the Black group, notwithstanding that persons of African descent were also afforded citizenship. This is not to say that Thind made this move specifically to engage in subordinating behavior. There were several elements at play. Thind's arguments were informed by his experience with racial hierarchy. He knew that proving himself as white would afford him certain treatment and benefits in the US and those coming after him, beginning with citizenship and continuing to resources such as basic humanity. I implore you to think critically here about Thind's proposed narrative to the court. Was he forced to take a position of recreating this rhetoric that perpetuated disdain for the darker races in order to advance his own cause? Did he even have a choice about what he was arguing? Did he believe his own arguments? Before we get more deeply involved in those questions, let's talk a little bit about what the court actually held. The Supreme Court ultimately held that Thind did not qualify as white under the statute because the term Caucasian, as used in the Ozawa case, actually meant Caucasian in its popular sense, not its scientific sense. If you are scratching your head right now, you should be. That is the exact opposite thing that the court said in the Ozawa case. The court is making all of this up. Race is a social construct. They found that Thind did not possess the requisite characteristics to be white. The test is not whether one's origins are the same as others that are considered to be white, the court said, but whether the common man would understand him to be white, which included people that the judges, those men in robes sitting on the Supreme Court, knew were white, the bone of their bone, the flesh of their flesh. So all arguments aside, all that mattered was whether those men sitting on the court felt like Thind was one of them. In order to advance his position in the breadline to naturalization and citizenship, a status that carried a number of rights and privilege, Thind was forced to pull from and reconfirm the racial hierarchy of whites on top and blacks on bottom. But note that Thind must have understood that the issue of race and classification was not as cut and dry as he presented it to be. And as a matter of fact, he submitted an exhibit to his brief to the court that showed that he actually understood what was going on and was not supporting the court, but in fact just trying to get his right to naturalization so that he could shape naturalization and citizenship for all those coming after him. He began to ask the necessary questions that challenged the construction of whiteness. He said, who is a person of African nativity or African descent? Is a Mongolian born in Africa of African nativity? If a Mongoloid marries a native of Africa, are his descendants persons of African descent? He continued, it seems clear that the Negro from Congo, the brown pirate from the Barbary Coast, and the native of Abyssinia, in fact, all native Africans and the descendants, by mere accident of their birth, are made eligible for citizenship. If, however, the applicant be not thus fortunate in his choice of parents or place of birth, then no matter how desirable or how highly cultured he must be, he will be denied citizenship unless he can prove that he is both free and white. He continued, should eligibility to citizenship be determined by the color of the applicant's skin, then where is the line to be drawn? Must the complexion be lily white? Or if brunettes are also included as well as blondes, how dark may a brunette be without becoming black? No skin is literally white, he said, and the degrees of colorization are innumerable, even in the same family, dependent upon occupation, climate, exposure. Perhaps most poignantly of all, Thind says, if the term white person refers to race rather than color, or absence of color, then what is the white race, and of what peoples is it composed? A very slight study of anthropology will convince even the most skeptical person that there is no clearly defined white race. We can stop there. Thind, in 1922, understood racialization. He understood that all of this was a social construct. In his exhibit, he was basically telling the court, I see you. I'm playing your game in my brief, but I don't agree with you. He was a very, very smart man. The unfortunate reality, however, is that the system, this apparently neutral, just, fair system, was steeped in the work of preserving white supremacy. And so the narratives the applicants told the court, the narratives that we now have about people like Thind, reflect the racial hierarchy and the realities that informed it. Thind told an untrue narrative, and now it is forever memorialized as history, as true, as unbiased, an accounting of reality as it must have happened. But it is more complicated than it seems. Yes, Thind used white supremacist rhetoric in his briefs, but we must locate that rhetoric in the system in which it was devised. And this story, Thind's experience, is not an isolated one. It is one where one is placed in the white category, he or she has access to certain resources. And when there are limited positions in that category, one is incentivized to create divides between him or herself and other groups. We've seen this kind of racial distancing and brokering time and time again when it comes to clamoring for the American identity. Chinese, for example, wearing buttons that said "not from Nippon" after the bombing of Pearl Harbor. Korean Americans proclaiming nationalist pride and model minority status as a stark contrast to the African American community in the LA riots, for example. Or even Sikh Americans after post 9/11 walking around the sign saying, "We are not Muslim." We must think critically about why we do these things, why Thind did what he did, and why we continue to respond in ways that entrench and strengthen racism. We must realize that the categorization of people as white, or not white, or black, or so on, did not and does not end with immigration. It extended to applying for jobs, home loans, access to healthcare, education, segregation. It extends to protesters on federal ground in Oregon who are afforded the protection of whiteness, and young black men walking down the street wearing hoodies afforded the tragedy of blackness. Whiteness confers certain advantages, rights, resources, or in the words of Professor Cheryl Harris, whiteness has become property which has blinded society to the systems of domination that work against so many. In protecting the property interest in whiteness, property is assumed to be no more than the right to prohibit infringement on settled expectations, ignoring countervailing equitable claims that are predicated on a right to inclusion. Query the predicament in which we find ourselves today, where a president-elect campaigned on promises of a return to greatness, as though that had no explicit ties to race, that campaigned on deportation promises and on explicit efforts to identify and register all Muslims, where the president-elect's chief strategist is a potential white nationalist champion. And so the pressing lesson for us today, which comes directly from Thind's bravery and difficult position, is that come 2017, when Muslims are required to register with this country, what test will the government use to determine one's status as a Muslim or non-Muslim? Will there be a modern-day appellant standing in the shoes of Mr. Thind, arguing that he or she is or is not Muslim in an effort to save himself or herself and argue to be filtered into a different racial category? Or will we rise up collectively, proclaim that we are all Muslim and all equally deserving of rights and protections in this country? Will we remake the decisions of the past, or will we learn from Thind's exhibit to his case and his co-opted narrative and dismantle the system from the inside out by simply rejecting its purported air of neutrality and legitimacy? These are all things I hope you'll continue to think about over the course of the weekend. Again, a huge thank you to all of you for being so attentive and for being so supportive of Sikh Lens and the film festival. Thank you.
Thank you so much, Jasmine.